The controversy surrounding the Tirupati Temple Laddu has reignited calls from Hindutva organizations to remove government control over Hindu temples. The Vishwa Hindu Parishad, part of the Sangh Parivar, has launched a nationwide campaign claiming that continued state management of temples reflects a mindset inherited from Muslim invaders and colonial British rulers. In response, Andhra Pradesh Deputy Chief Minister Pawan Kalyan has proposed establishing a Sanatan Dharm Rakshan Board. This board would address various temple-related issues, including concerns about their desecration, land disputes, and other religious practices. But how did Hindu temples come under government control? And what are the arguments for and against ending it? We explore the history, legal framework, and current demands from organizations like the VHP and RSS to hand temple administration back to Hindu communities. While Muslims and Christians manage their places of worship through community-run boards or trusts, the government has significant control over Hindu, Sikh, Jain, and Buddhist temples. Many states have laws that allow them to oversee the administration, income, and expenses of Hindu temples through boards that include government representatives or officials. In Tamil Nadu, the Hindu Religious and Charitable Endowments Department manages many temples, including the Tirupati Temple, which is run by the Trimula Tirupati Devasthanam (TTD) under the Andhra Pradesh government. The state appoints the head of the TTD. Governments often take a share of the income from temple offerings to fund temple maintenance, support smaller temples, and finance welfare activities like hospitals and schools. States with laws regulating temple management include Tamil Nadu, Karnataka, Andhra Pradesh, Telangana, Kerala, Maharashtra, Odisha, Himachal Pradesh, Bihar, Madhya Pradesh, and Rajasthan. Specific institutions like the Vaishno Devi Mata Shrine have dedicated laws. These regulations are based on Article 25 of the Indian Constitution, which ensures freedom of religion. Both the central and state governments have the authority to legislate on religious institutions. India has around 30 lakh places of worship, mostly Hindu temples, according to the 2011 census. Historically, kings donated land and wealth to these temples, making them cultural and economic centers. Cities grew around temples, boosting local development. The British recognized the influence and wealth of temples, leading them to intervene in temple administration. Between 1810 and 1817, they passed laws in Bengal, Madras, and Bombay to oversee temples, claiming that income was being misused. Due to backlash against British control over Hindu temples, the Religious Endowments Act of 1863 shifted management to committees. However, laws like the Civil Procedure Code and the Charitable and Religious Trusts Act of 1920 allowed the government to maintain significant influence. The first law specifically governing Hindu temples was the Madras Hindu Religious Endowments Act of 1925, which was based on the Government of India Act of 1919. This law and its amendments created boards with substantial authority to oversee temple management, sometimes allowing them to take full control. Independent India retained much of the legislative control that the British exercised over temples, with the 1925 law acting as a blueprint for various states. However, due to backlash against British control over Hindu temples, the Religious Endowments Act of 1863 shifted management to committees. Laws like the Civil Procedure Code and the Charitable and Religious Trusts Act of 1920 allowed the government to maintain significant influence. In 1959, the RSS called for community control of temples, urging the Uttar Pradesh government to return the Kashi Vishwanath temple to Hindus. The Akhil Bharatiya Pratinidhi Sabha highlighted growing government control over religious life. In 1988, the issue was raised again, following protests from religious leaders in South India. The VHP has advocated for temple autonomy since the 1970s and passed a resolution in 2021 for a central law to remove government control. The BJP has also supported this demand. Last year, PM Narendra Modi criticized the Tamil Nadu government for controlling Hindu temples, a claim strongly denied by CM M.K. Stalin. Previous BJP MP Satyapal Singh introduced a private member's bill on the matter in 2017 and 2019. In December 2019, the Uttarakhand government created a board to manage Char Dham temples, but withdrew the act in 2021 due to public protests. Similarly, in 2023, Madhya Pradesh reduced state control over temples, while Karnataka plans similar changes but did not implement them. However, a central law on temple governance has not yet been established. Legal experts, including senior lawyers Fali Nariman and Rajiv Dhawan, have criticized government control of temples as a form of nationalization of religious endowments, but the courts have generally hesitated to intervene. In 1996, the Supreme Court upheld an Andhra Pradesh law that abolished hereditary chairmanship of a religious trust, noting that it was based on recommendations addressing mismanagement and corruption. In more recent news, in 2022, former BJP spokesperson Ashwini Upadhyay filed a petition to remove government control of temples. The Supreme Court supported the current system, stating that it benefits society and warned that changes could revert temples to being just places of wealth. Upadhyay eventually withdrew his petition. While there have been calls for greater independence for temples from government oversight, legal precedents indicate a complex balance between religious rights and state regulation, with the courts largely favoring the status quo.